for those who are unaware and those who are aware, there's a court case going on out there in Canada. And that court case is between some individual named Joseph Power versus the Attorney General of Canada. And we can find this court case on CanLEAP. As you can see here, the court case started originally in October 2020, nearly 3 years ago. And it went through a trial division, went through the appeal division, and the Attorney General lost both times. But he has been granted the right to appeal to the Supreme Court of Canada, which of course he's choosing to do. So right now the case has been going on for nearly 3 years already, and there's been no resolution to this. The gist of the case is as follows. At the hearing of the motion, the Attorney General argued that the Parliament and the executive branch of government are protected from all liability when performing an essentially legislative function. According to the Attorney General, the mere enactment of legislation by Parliament, with the assistance of the executive branch, cannot give rise to any entitlement to damages under Section 24.1 of the Charter, because they have immunity, because they're immune from damages under the Charter. So they're saying that if the government agents operate their duties under the statutory powers, and those statutory powers limit and abridge your right, then you shouldn't be entitled to any damages, any moolah, no money, no damages, if you catch them. He maintains the only remedy available to anyone affected by legislation later found to be unconstitutional is a declaration under Section 52.1 of the Constitution Act that the legislation violates the Charter and is therefore of no force or effect. So he's saying that if you catch us, and you catch us limiting and abridging a right, then the only restitution that you have, the only remedy that you have, is that that law should be declared of no force or effect against you. But you shouldn't be entitled to get any damages. He maintains the only remedy available to anyone affected by legislation, later found to be unconstitutional, is that declaration under Section 52.1 of the Charter of Rights and Freedoms. And they use the subject or player here, anyone. And some people are reading this case, and some people are hearing about this case, and they're saying, oh my gosh, they're coming against my human rights. They're coming against my natural rights. Look what he's trying to do. Oh no, it's all over. London Bridge is falling down. Falling down. London Bridge is falling down. So the judge, he quotes another court case, Central Canada Potash Corporation versus Government of Saskatchewan. And this is what he writes. In other words, invalidity of government action without more clearly should not be a basis for liability for harm caused by the action. All right, so he's saying that the invalidity or the wrong actions of the government, right? Because they're talking about action here. He says without more, if they just perform the wrong action and there's no more to base what's transpiring here on, then this shouldn't be the basis for liability for harm caused by the action. So he's saying if they took the action, well, the action itself shouldn't be the liability for the harm, unless the action that they took, there was something more that went with it. So let's apply that in a quick way to our fundamental right, to our natural right. If you begin to exercise a natural right or your fundamental right, what's the first thing you're going to do? You're going to contact the executive powers, right? And you're going to send that claim of recognition, and you're going to tell them that I want to be recognized under my full legal capacity, and I'm not playing statutory creature anymore. And I'm not going to be subjected to your statutory powers. Well, you gave them some more, right? You gave them more, right? So now when they apply an enactment, or they take action against you under an enactment, and this enactment limits and abridges your fundamental right, well, you have more. than what they just did, right? You have more. And the judge was very clear, and I'm going to show you why he stated it like this. He said the invalidity of government action without more. So he's putting a qualification. If it's just an action they're taking, well, you can't come against them then. But if it's an action with something more attached to it, then you can come against them. All right, if they take this action against you, right, after you gave them your claim of recognition, then, like I said, there's more attached thereof, right? It goes on to say, in the legal sense, therefore, both public officials and legislative bodies enjoy limited immunity. The Attorney General wants to have absolute immunity. But here the courts say they have limited immunity. Well, against what? Against actions in the civil liability based on the fact that a legislative instrument is invalid. So if you've been studying your natural rights, your human rights, and how to give effect to them in domestic law, then some alarm bells should have went off in your head when I just read that, right? Because what are they talking about here? Are they talking about your fundamental rights, your human rights, your natural rights? Or are they talking about something that's going on in the civil side of the law? Actions in civil liability. So they're not talking about fundamental rights. They're not talking about charter rights as it comes to the International Covenant, human rights, natural rights, fundamental rights. They're talking about civil liability from a civil point of view, from a statutory point of view, as a statutory creature. I believe when all this is said and done at the Supreme Court of Canada, the Attorney General is going to win. He's going to get absolute immunity, or the office is going to get absolute immunity concerning civil liability based on the fact that a legislative instrument is invalid. He's going to get it. Mark my words. It's going to take another 3 years for this case to settle. And there's a reason why they're doing that. But when this case is settled, they're going to get absolute immunity, but only on the civil side. Go on here. It says, however, as I stated in Gaumont versus Quebec, since the adoption of the Charter, a plaintiff is no longer restricted to an action in damages based on the general law of civil liability. What's the court trying to say? Well, civil liability, where does that come out? Does that come out in your fundamental right? Does that come out in your natural right? Or does that come out when you're acting and operating as a statutory creature, exercising civil rights and duties, thereby creating civil liabilities? Now, here he's talking about the Charter, right? And look what he says, in theory. Well, what do you mean? What do you mean, Judge, in theory? What's he trying to say? Well, a theory, right, is a set of principles on which the practice of an activity is based. Or a theory is an idea, a thought, used to account for a situation or justify a course of action. That's the legal definition of theory. And here the judge says, in theory, a plaintiff could seek compensatory and punitive damages by way of appropriate and just remedy under Section 24 of the Charter. Well, what do you mean in theory? Not in action? Well, it would lead to action, right? But you have to have the theory down pat, right? You have to understand the theory that you're going to use, right? Because again, it's a set of principles on which the practice of an activity is based. Well, what's my activity? I'm invoking my fundamental right, my natural right, my human right under Article 24 of the Charter. That's the activity that I'm taking. And I have the set of principles, I have the laws, I have the operations of laws that allows me to take the activity. And here the judge is very careful what he's saying. Because let me share with you, all this is a setup. From the first time that this has gone to court, I believe this is a setup, and they know exactly what they're doing. They are going to remove civil liability against the Attorney General. And they're going to claim that they're doing it in order to create an effective balance between your constitutional rights as a statutory creature and the need for effective government. But even though they're going to do that, right, the judges are still clearly saying that you can go still to the court system under Section 24 or under a charter violation. But you can now go there only for a limitation or abridgment of a natural right. You can only ask for punitive damages or compensatory action on behalf of the plaintiff, which would be the AG, for a limitation or abridgment of a fundamental right. And you have to go there, right, understanding the principles. And you have to go there, right, understanding what activity you're going to take. So even though the judge here is saying that the charter is no longer restricted, you see that? Is no longer restricted to an action in damages based on civil liability. They're telling you right there, the charter doesn't only operate under civil liability, but in theory. What does that mean again? In a set of principles, under a set of principles, under a set of laws, a plaintiff could seek compensatory and punitive damages by way of appropriate and just remedy under Section 24. You can still take action against them. Why? Because their obligation to protect and ensure your natural right, they can never do away with. It's part of the inherent jurisdiction of the court, and it's part of the obligation upon the executive powers. And they can never do away with it. What they can do away with is your civil rights, their civil obligation. And they're going to do it. They're going to do it. We already see how. They're going to declare that this is for the better effective government of Canada. That now when a law has been declared unconstitutional, you can no longer seek damages in the civil side. You can no longer seek civil liability against the Crown for it. But that has nothing to do with us. That has nothing to do with my fundamental right, with my natural right. So I keep going in this judgment here. Thus, the government and its representatives are required to exercise their powers in good faith and to respect the established and indisputable laws that define the constitutional rights of individuals. However, if they act in good faith and without abusing their power under prevailing law, and only subsequently are their acts found to be unconstitutional, they will not be liable. Well, right now, right, it's the Deputy Attorney General who has the obligation to make sure that these established and indisputable laws actually do follow the constitutional rights that are in the Constitution of 1982. And they're saying that if the agents follow these laws because they believe these laws are constitutional, because the Attorney General declared them to be constitutional, but then later it's found out that the actions they were doing were indeed against the Constitution, well, they will not be liable. Well, why? Why are they saying this? Because they're saying that by doing this, the effectiveness and efficiency of government action would be excessively constrained. Laws must be given their full force and effect as long as they are not declared invalid. Well, where have we heard this before, right? The judges of the court, right? They're under that same understanding that the enactment has full force and effect. It hasn't been declared invalid. The Deputy Attorney General checked it out and everything's okay. And here they're saying that government agents and the government ministers must look at law as having full force and effect until they're declared invalid. Thus, it is only in the event of conduct that is clearly wrong, in bad faith, or an abuse of power, that damages may be awarded. Okay, well, then how do we make the crown, right? Talking from our point of view of giving effect to our human rights, of giving effect to our natural rights, how do we make the crown then take actions that are clearly wrong, or take actions that are in bad faith, or abuse the power that they have, in order that damages may be awarded to us? Well, it goes back to the beginning of this video, right? When it says more had to be done. More. Well, what's the more? Well, the claim I laid. My communication with you, right? My communication with you was exercising my theory, as the judge put here. My communication with you was bringing forth the principles of natural law and how they express themselves in the covenant and how they express themselves in the charter and how they are there for me to exercise and stand upon. Now I wonder how many of you caught it. I wonder how many of you saw this. And for those who follow my videos, if you caught it, and you usually leave messages, then let me know, yeah, I caught it when you read it. And for those who follow my videos, go and get the court judgment then. And put it on the comment section so that others could see it and read it. So here, the court said, laws must be given their full force and effect as long as they are not declared invalid by the court. Is that what it says? No, right? What have we learned from the courts about declaring that a statutory power is invalid, is of no force or effect? The courts have already said, right? It doesn't take a court judgment, does it? No, it doesn't. What does it take? Well, it takes a theory. It takes a theory. A theory what? Being presented to the crown on your behalf. And within that theory, right, you're declaring to them that those statutory powers are invalid. They're invalid. And if they go forward or take actions against you individually, against you personally, then that's clearly wrong, right? That's in bad faith, right? And it's abuse of their power. And in that situation, the courts are saying, well, damages may be awarded. Damages should be awarded. So in no way are they limiting and abridging our access to the courts and our access to the inherent jurisdiction and the administration of justice. What they're doing, again, is all on the civil side. But the courts are very clear, right? What they're saying here. That all these laws, all these statutory powers that the Attorney General, Deputy Attorney General signed off on, all the government agents and all those who work for the government, they must take them, that they have full force and effect as long as they are not declared invalid. Well, who gets to declare them invalid? I do. By just writing a letter and saying, oh, well, it's invalid, so no effect on me, I'm a man, it's invalid. No, right? It's not going to work, right? Your theory is not going to work. Your theory is going to fall apart. What would you have to do? Well, yeah, you have to find which statutory power you're talking about. And you have to find within that statutory power where there's a limitation and abridgment placed upon you. And one of my videos showed you concerning the inhabitants being incorporated. Well, there you go, right? Part of your theory. And you can declare that enactment invalid. Why? Well, because it limits and abridges your natural rights. And it doesn't take a court judgment to declare that invalid. It takes your theory. What's that? Your principles. Properly based in law. Where would you go? Well, into the covenants, right? And bring out the rights that are in there that protect you from this operation of law that they did to you. And then flow into the charter, right? And call upon the law, the article of laws in the charter that protect you from what they did to you. And in your communication, you would be declaring that that law is invalid and your actions against me are invalid. And if they choose to go forward from that point, then what did they do? Well, they did clearly wrong. They did it in bad faith, and they abused their power. Yeah, but I didn't know I did it wrong. I didn't know. Bad faith, I didn't. I know I abused my power. Well, it doesn't matter that you didn't know. You did it anyways. You did it anyways. Why? Well, the courts have already said it doesn't take a court judgment to say that an enactment is invalid. What does it take? It takes a proper theory. That's what it takes. It takes a proper theory. And when I presented my proper theory to you, you laughed at me. And when I presented my proper theory to you, you didn't respect it. Now you're going to see. Now you're going to see.